Welcome to A Taste of Justice. I am Professor Angela Mae Kupenda. This semester, I'm posting videos on First Amendment law as I teach my students remotely. But this series is for all of us. The Constitution says we, the people, in order to establish justice. And I believe that learning is a pathway to enlightenment and enlightenment to justice. This series is also for my students to give them just a little something extra to supplement their reviews to the material and the detailed cases we're studying in our remote classroom. Now, if you look at the text of the First Amendment, it is very short indeed. However, the court has interpreted the meaning of the First Amendment in extensive case law, and the text of the amendment itself, and also the cases and the laws pursuant to the Constitution, are the supreme law of the land. All explanations here, however, are my own and are not to be ascribed to my school or to my students. For information purposes only, I will tell you I'm a professor at Mississippi College School of Law, and I've been teaching for almost 30 years now. So let's get right to it. In our earlier clips, we talked about some basic rules in interpreting the First Amendment, specifically as related to speech and protest. One rule we discussed was the First Amendment protects pure speech. The First Amendment does not protect pure conduct. Then we went to a very nuanced rule, and I'm going to state it again here. Generally, the government may not regulate the content of pure speech. Generally, the government may not regulate the content of pure speech. And then there is an unless. There are several unlesses. Unless the government satisfies a very high level of review. It's called strict scrutiny, the most exacting level of scrutiny. In order to regulate the content of pure speech, government must show that it has a compelling governmental interest and that the restriction on speech is narrowly tailored to that governmental interest. Now that's the general rule, right? And that's an unless. But then there's more. Generally, the government may not regulate the content of pure speech unless the speech is in an unprotected category. If the speech is in an unprotected category, government only has to satisfy a very low level of scrutiny. Government can regulate that speech with a low level rational basis, just a legitimate governmental interest, and the restriction on the speech is just rationally related to that interest. So the question becomes, what speech falls within an unprotected category? And what are the rules to determine if a given speech, a given publication, a given statements are unprotected speech? Now, the court has recognized, and look, I have my notes here to help keep me on track. This clip is going to be a little bit longer because I want you to understand those cases that I pitched to you, I pitched the hypotheticals to you in a previous clip. So now I'm going to go back. I know you've thought on them. And if you're in my course, I know you read the detailed cases. I'm going to go back and summarize how the court ruled in those cases. So the court has determined that there are some generally recognized categories of unprotected speech. And we're going to look at those categories over the coming weeks, one by one. So the first category of unprotected speech, where if the speech is there, government only has to satisfy a low level of review, is speech that advocates illegal action. The court has held that generally, for speech that advocates illegal action, government may regulate it with a low level rational basis. And notice I said government may regulate it. Government may choose to regulate it, or government may choose to not regulate it. But government may constitutionally regulate it with a very low level of scrutiny by the court. It only has to satisfy a legitimate governmental interest, the regulation, and it only has to be rationally related to that interest. It doesn't have to be wise or smart or detailed or what have you. It's a low level of review. Now, well, let me just mention, there's some other categories of unprotected speech we will be getting to in the coming weeks: defamation, obscenity, and a category called fighting words. So, but we're going to start with speech that advocates illegal action. Now, we're going to do several things. This clip is going to look at the historical cases. The cases going way back that some people say are completely gone, but we'll see. Then we're going to look at what is called the modern day test. It comes out of a case called Brandenburg that you hear about sometimes in the news. And then thirdly, we're in another clip, we're going to look at a case that occurred after 9/11, after 9/11. And we will talk about the challenges that 9/11 placed on speech rights. Okay, now, as I said, in the previous clip, I pitched a number of case hypotheticals to you. In the text at the bottom of this video, I've listed the names of the cases and the dates, so you can go and Google them or read them for yourselves, so my students have a case book where they can go back and review. Look, you're like, why? Well, you need to check me, right? You want to check me. You want to check my explanations of the cases. Young people in my classes and in my family and community check me all the time. Now, most of the time they find out that I'm correct because I'm indeed very careful in my explanations, or I try to be, but I don't mind being checked. And that is a part of learning, to critically examine what you are told to see if it is indeed accurate. So let's go to the cases. The first case that I pitched to you is called Schenck v. United States, a 1919 case. The country was at war and had a mandatory draft. Now, for many of you, there has been no mandatory draft in your lifetime, but there has been in my lifetime a mandatory draft. Putting it in a simple way, when your number comes up, you go and you serve in the military, whether you want to or not. It's a little bit more nuanced than that, but that's the basic idea. So here, the speaker went to a recruiting office where individuals were to go to sign up for the draft, or if their numbers came up, where they would report. He went there and he gave a speech trying to encourage individuals not to go. Even if your number has come up, he said, you should not go and fight in this war. He believed it to be an unjust war. So he was arrested, the speaker, and charged with being an affront to the country's military effort. Look, the government said we need people to fight in this war. And you're out there doing those speeches, disencouraging people from fulfilling their obligation. So they arrested him. Now, there was no evidence brought before the court that showed that people actually listened to him and didn't go as they were called. There was no evidence that his speech had that effect. So right now you're thinking, well, he didn't go to jail then, did he? He went to jail and he stayed in jail. What the court said was this. The court said a number of things, but first, that his speech did fall in an unprotected category. Therefore, government could regulate it with a low-level, rational basis level of review. The court says in determining if speech falls in this unprotected category, you have to examine the factual circumstances. You have to look at the times. We're in the midst of war. The audience who he was talking to, people who were supposed to be signing up, the nature of his speech. You have to look at all of those circumstances. The court, and Justice Holmes is the Supreme Court justice who authored this opinion, and that becomes very important for later. Justice Holmes said, the First Amendment is not absolute. He said, it does not protect a person from falsely shouting fire in a theater and causing a panic. So the court held, with Justice Holmes writing the opinion, said that whether the speech is unprotected or not, said if the speech is unprotected, he can be punished for giving the speech. The court said that if the speech is unprotected, whether it is depends on whether the words are used to create a clear and present danger, whether the words are created okay, here I come. Whether the words create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. Justice Holmes said you have to weigh the circumstances. It's a question of proximity and degree. Then he said something else really interesting. He said that when a nation is at war, many things that can be said in times of peace, the government has a right to punish you for saying them in times of war. Now, That statement gives me a lot of pause. You're not going to complain about a war, are you, in times of peace? But he seems to suggest that your speech rights are lessened during a time of war, because Congress and the federal government have certain goals, and we give them leeway. We give them, as long as it's rational what they're doing, they're allowed to suppress the speech. Now, he also added, it's not critical here to look at whether the speech was effective or not. So Justice Holmes and the Supreme Court, they affirmed the conviction of Schenck, and he indeed remained in jail. Now, do you agree with the court? Do you agree with Justice Holmes? The students in my class have to do commentary in their chronicle. They do a chronicle and commentary and pick a case they feel strongly in favor of or they strongly disagree with. But I posed that question to you here today. Let's go to the next case. The next case, you may have heard of him, Eugene Debs. Debs versus the United States, also a 1919 case. Now, Debs was a national figure and a very popular figure too. He gave a very strong, very passionate anti-war speech, but he didn't go down to the recruiting center to give this speech. He gave this speech at a socialist convention, speaking to individuals who likely agreed with him. And so here he was arrested and convicted for his very strong speech. Should his speech be protected, or should it be unprotected? And partly because he's a national figure, popular, a strong, eloquent speaker. Well, his speech, the court said it was unprotected. And for him to go on to jail for a 10-year sentence, prison sentence for that speech. Now, how did the court get to this point? Justice Holmes again wrote the opinion using a similar analogy to what he used in the Schenck case. But let me tell you something about this case. Eventually, well, let me go back. Eugene Debs, even in prison, continued to be very popular. He had run for president before, but his name was on the ballot while he was in prison. And he got more votes than some of the others. He got almost 1 million votes to be president while he was serving his prison term. Now, when eventually Debs' sentence was commuted, meaning for time served or what have you, and guess where he went? Guess where he was invited to go as soon as he got out of prison? As soon as he got out of prison, he was invited to visit at the White House. Look at that. Eugene Debs, sentenced for his speech and later invited to visit, and I'm thinking probably have tea at the White House because the then president wanted to see him and shake the hand of such a powerful person. The cases go on and on. There was a case about some cartoons sent in the mail. Now, that case, I mentioned it below, Masses versus Patton, is really not a Supreme Court case, but it's included for a reason. In that case, Judge, he never became a Supreme Court justice, Judge Hand said, wait a minute, people, wait a minute. A cartoon, some poems, we need to require a higher showing by government to punish this speech or to prohibit the distribution by mail. Now, that case, and you can check it out, but Judge Hand's view was reversed by the Second Circuit, the court over him. But it's an important case. It's an important point of view of Judge Hand, because ultimately his view that was rejected in 1917 becomes the view of the court. We'll get to that later. So if people disagree with you today, your view could still become an important view, even if it is currently rejected. Now, let's talk about just a few more. So, Justice Holmes has been writing many of these Supreme Court opinions. The other justices are signing on, but Justice Holmes is the author. He signs the opinion that it's his words. But at some point, Justice Holmes starts to think, we often debate in class, did he change his view? Is he being intellectually dishonest by not just saying it out? I changed my view, but let me tell you what happened. Okay, a case. Okay, I'm sorry, I'm going so fast. I'm getting excited about this material. Isn't it interesting? So the case is called Abrams versus the United States, also in 1919. There were two men who were opposed not so much to a specific war effort, but I'm going to frame it like this. They were opposed to a foreign policy approach of the United States. So they had all of these pamphlets. They made up, I think it was maybe 1,000 or 2,000 pamphlets. They were in New York and they wanted to get them out. So what did they do? They went upstairs in this building and they took their pamphlets and threw them out the window in New York City so they would spread all over the streets. And they were hoping that people would pick them up off the street in New York City and read them. And they were convicted. Now, when the case made it up to the US Supreme Court, the higher court, Justice Holmes said, I don't think these men should be serving a long prison sentence for this. He said, this case is different from the Schenck case. It's different from theirs. He said, if you all keep these men in jail, I'm going to dissent. A dissent is a written opinion in disagreement. The other justices on the US Supreme Court said, wait a minute, Justice Holmes, we're just following what you've been saying all along. He said, no, this is a different situation. I'm thinking about dissenting. So several of the justices, they go over to Justice Holmes' house. Yes, they do. They go to his house to try to persuade him not to dissent. They say, you're changing the view of the court. He said, no, I'm not. This case is different. Here we have two silly unknown men throwing these pamphlets out a window. That's not enough. Their speech is protected, it's not effective, and it's not having an effect, so they should not have this long prison term. The justices who came over, they did not stop there. They talked to Justice Holmes' wife to try to get her, she agreed with the other justices, to persuade her husband not to dissent in the case. But nevertheless, the court upheld the convictions. Justice Holmes dissented. Now, he said this case is different. It's not enough here. This speech was not, it did not, well, it may have advocated, but it was not successful and it did not have an effect. So they cannot be punished now. This speech does not fall in that category like the speech from the earlier cases. Justice Holmes' dissent is remembered more than a majority opinion. Now, let me add here, Justice Holmes said something in dissent, a theory he argued that is a well-known theory that people talk about, even own to this day. Justice Holmes says this. His theory is called the marketplace of ideas theory. He said, sometimes you have to just allow, let me go back. Maybe he didn't say sometimes. Here's his theory. He said, allow the speech into the marketplace of ideas. And then over time, the truth will win out. If you let the speech in, the hate speech, the speech in disagreement with a war, if you let this speech into the marketplace, people may buy an idea or not buy an idea. And ultimately, the truth will win out as people compare the various ideas. Now, what do you think about that? Google it and check it out. The marketplace of ideas theory, which actually argues for more free speech. Now, I know this is a long clip, but I got to tell you about just a couple more. The court also held in a case called Get Low that the states could also regulate pure speech if it falls within this unprotected category, that the states had an interest in maintaining peace, right, in policing, in maintaining public security. So in this case called Get Low, the court held and that the state of New York had acted properly. That case is important because of, the thing about states may act pursuant to that individuals can bring lawsuits against the state under the First and the 14th Amendments. That's a side point. But this case is very important for Justice Holmes' dissent again. He disagreed with what had happened. Justice Holmes' dissent has some very eloquent language in it. He says every idea is an incitement. So how are you going to punish individuals for using incitement, a language of incitement, when every idea is an incitement? He also says that eloquence, the eloquence of a speaker may set fire to reason. So think on those and read about it. But I want to tell you about Charlotte Whitney. Now, Charlotte Whitney versus California, a 1927 case. I say that her case stands for this: be careful what organizations you join and what meetings you go to. Charlotte went to this meeting, and she believed that the organization was advocating for change through peaceful measures. But when she got there, she found out things were not going the way she had thought they would be. The people in the group began to advocate for the overthrow of government through the use of violence. And Charlotte alleges that she was opposed to that, and she tried to stop them. She said, no, this is not the way. We should bring about change with peaceful measures and through the system. Charlotte was arrested, and she was convicted for an extended prison sentence. So here the question is Charlotte's conviction, is her speech, is her conviction unlawful because her speech was protected? Or is her speech that advocates illegal action? Well, the court upheld her conviction, and Justice Holmes and Justice Brandeis actually concurred with the majority, but their concurrence reads like they're really disagreeing. They end up blaming pretty much her lawyers for not introducing certain evidence, but their concurrence has some very strong and interesting language. They're cautioning the majority on the direction that it is taken. In one place, they say that, oh wow, men feared witches and burnt women. So they're cautioning the court that irrational, not rational fear, but irrational fear should not be a basis for suppressing speech. Now, later on, the court held that mere membership in an organization, mere membership cannot be punished. But what does that mean? If you're a member of a group and you hold an office, if you work on a committee, is that enough? Especially post 9/11. And the cases, they go on. We have this case called Dennis versus United States about communism, and the court saying that government can regulate that more because the communist organization, it said it is a highly disciplined large organization. All of these cases are the historical cases. And right now, I know you're asking me, are all of these cases still good law? Does the court still rule in this way and find speech like this, speech that advocates illegal action, and therefore a person can be punished for making such speeches or distributing such papers and pamphlets out a window, or going to and participating in certain types of organizations? Is that still the law? I can hear you asking me this. My answer to you is, why don't you watch the next video? This video is covers the historical cases. The next one looks at the modern day test. And then the next one at post-9 election, post-9/11, and the resulting case I'll talk about. Are these cases still the law? For now, I say, remember, learning is a path to enlightenment, and enlightenment takes you on the path to justice. My goal here is to offer you a taste of learning about the First Amendment and hence at least a taste of justice. Subscribe, sign up for notifications. You don't want to miss a thing. See you next time.